they were barred from coming in. They had been there since 8 o'clock.
That one we shall discuss, so we can have a meeting here. Let us pass by the post.
Mr. Temple of Justice.
You people need to know what the daughter was.
Mr. Temple of Justice. Not the balance.
So this being a public trial, we are urging the court to order the orderlies at the front gate of this court building to let members of the...
It's okay, I will come back to that. Let me first go to the way forward of 3:20. I will come back to that.
Way forward, we were also going to come back to that. In view of your ruling, we will need to take instructions from our clients. We did not expect or know how the ruling would go. We naturally need to go and take instructions. We would also urge that the orderlies are impressed, the orderlies in court, even when removing a person who is agitated, they must not mishandle. They should handle people properly, and especially if it's a female, she should be handled with extra care, lest the handling amounts to indecency. It's just been removed from the court. Just to bring to your attention, that she is the daughter of Mr. Obed Lutare, and her emotions as a human being ought to be understood in that context. She obviously appeared to have something she wanted to communicate to the court. It may not have been communicated the way the court would expect. We are urging you to apply your discretion as a human being and to order for her release. She can be warned that next time she wants to communicate with the court, it's done differently. But just giving the court the context of the emotion that were outpouring. We will be able to sit down with her and listen with her. But also to again remind the court that all these frustrations are being exacerbated by the treatment of the public at the gate. So people are coming in charged after being totally mishandled at the gate.
Especially where the complaint is pending is an independent and impartial court. In accordance with the plain and ordinary meaning of Article 28(1) and Article 44(c) of the Constitution. Counsel for A1 and A2 moved to court under Article 137, 3b, which briefly states that where any question as to the interpretation of this Constitution arises in any proceedings in a court of law other than a field of matter, the court shall, if any party in the proceedings requests it to do so, refer the question to the Constitutional Court for decision in accordance with Clause 1 of this Act. Counsel for A1 and A2 made submissions to the above. One said that all the submissions of Counsel for A1 and A2 were put into consideration, but briefly they submitted that in light of Article 28(1) and Article 44(c) of the Constitution, there is a complaint pending against the trial judge before the Judicial Service Commission made by A1 and A2 seeking removal of the judge from office. Council submitted that there is a need in calculating Article 28(1) for the 4C of the Constitution. That the question to be answered is whether this court can continue to be an independent and impartial court within the plain meaning of Article 28(1) of the Constitution, bearing in mind that the article cannot be derogated from. That the question is whether, in its plain meaning, the court faced with such circumstances can be or even seem to be independent and impartial, particularly for purposes of trying those people who have brought the complaint against them. Council contended that Article 137(5), paragraph 1, paragraph A, gives this court discretion, while paragraph B does not grant such discretion and is mandatory in its terms. Council further submitted that the article is framed in a way that court, while doing its work, may find an issue and make a reference that if any of the parties on whose behalf that work is being done asks it to refer, the violation alleged and its effect before a question could be referred to the Constitutional Court. In the Constitutional Petition number 46 of 2011 and Constitutional Reference number 54 of 2011, in the case of Honorable Sambo Kesa versus Attorney General, at page 39, their lordships stated as follows: that both the Supreme Court of Uganda and this court, that is Constitutional Court, have in a way dealt with this issue. In a Constitutional Appeal number 2 of 1998, Ismail Selgo versus Kampala State Council and Attorney General, the rest of their lordships of the Supreme Court expressed no contrary view to the holding of Wambuzi CJ, as the then was, who stated that, in my view, for the Constitutional Court to have jurisdiction, the petition must show on the face of it that the interpretation of the provision of the Constitution is required. It is not enough allege merely that a constitutional provision has been violated. Following the above holding, this court, in Constitutional Reference number 31 of 2010, Uganda versus Gonza Francis, held that Article 137(5) should be read in the proper spirit of the Constitution, that the applicant must go further to show prima facie the violation alleged and its effect before a question could be referred to the Constitutional Court.
And of course, as I raise it, I would request that the report reflects the unfairness that is being subjected to our clients. Because my submission or my concern is premised on the same. My Lord, just as you might be aware, all of us on the legal team have roles. And one of my roles that are performed religiously for now a year is I am the one who visits the applicants or the accusing persons. I therefore consequentially am the one who takes documents for execution, conducts prison interviews, etc. My Lord, the unfairness I'm trying to cite is that yesterday when I took documents for execution, the officer in charge of prisons, a gentleman I think called Besigye, ordered me to always be at the prison at 2 p.m. Now, my Lord, it's concerning because the law and the regulations of prisons say that visitors are received until 3 p.m.